Good afternoon all and welcome to this CPD. Yes, here we are, 30 March 2023, the second last day of the CPD calendar. I suspect all of you have your points and you're here because of your love of the law, in particular insurance and liability law. So, as I say, welcome. At the outset, may I acknowledge and pay my respects to the First Nations persons, in particular the Gadigal people of the Eora Nation, the traditional custodians of the land on which we are conducting this CPD. I pay my respects to their elders, past and present. Now, in terms of what we are going to traverse this afternoon, I'm going to be looking at 4 recent appellate court decisions. When I say recent, I actually mean very recent. The earliest one, which is the first one we're getting to, is from December 2022. The others are from this year, in fact. I'm going to have a look at them. In the time available, obviously not going to be a detailed analysis, but certainly draw your attention to the key issues in each of the cases. To those watching online, and if you have questions, I understand that there's a chat facility via YouTube that you can communicate with Jackie Charles, who's here, the clerk of our chambers, and at the end when we deal with questions, then she can raise any issues there with me. Okay, so the first case of the 4 matters I said that we'll be dealing with is the matter of Allianz Insurance Limited and Delaware Apartments, a decision of the High Court, 14th December 2022. Of the 4 cases, this is the only pure insurance case. The other ones, I guess you'd categorise as liability matters. So what happened here is that we had a claim by a body corporate for an apartment block which is located in northern Queensland. In around March 2017, the block suffered substantial damages due to a tropical cyclone called Tropical Cyclone Debbie. The damage, as it transpired, revealed that there were defects in the building, and they were defects that the body corporate, the insured party, had failed to disclose to the insurer, and it was accepted that that there had been a non-disclosure within the meaning of the Insurance Contracts Act. So then, having considered the claim that was made in about May 2017, the insurer said to Delaware, well, look, despite the non-disclosure, we will honour the claim, albeit it identified 2 categories of damage. It said we'll pay out in respect of one category but not the other. It's not entirely straightforward. The gist of what they were trying to do is to say, well, we won't pay you in respect of the damage as a result of those elements that were not disclosed, the defects not disclosed to us, but we will pay for the other stuff. But that, as I say, it wasn't entirely clear, and there was also a proviso that the body corporate had to cooperate with Allianz regarding the adjustments of the claims, and also assist if there was to be any potential recoveries from third parties. Now, over the next 12 months, Allianz undertook investigations. It discovered further pre-existing issues, and parties were essentially unable to agree on what was the appropriate level of work, having regard to the initial, the letter indicating that there was going to be some form of cover provided. So then in early May 2018, Delavue's lawyers sent what the judge, what was described by one of the judges as a a firm and direct but not rude letter, essentially saying, look, to the insurer, your failure to state or identify your position with clarity has meant the case has been delayed, it's not good enough, it's a breach of duty of good faith, and maybe breach of contract for which we're entitled to damages. So this was sent off to Allianz. Allianz then replies at the end of the month making an offer. It says, we're prepared to pay for certain repairs. And essentially they identified what the repairs were, and those were repairs quantified at just over $900,000. They said, you've got to wear these other repairs, and they were repairs in the order of about 3.5 million. And if you don't accept this offer within 21 days, we will rely on our rights under section 28(3) of the Insurance Contracts Act and reduce our liability to nil. So in a sense, they were saying, well, accept this or you're not getting anything. Delavue wasn't happy with that. They said, no, you can't do that. They say you waived the section 28(3) defence. Now, perhaps whilst we're dealing with that, for those that don't know, that's obviously the Insurance Contracts Act provides that in a case where there is non-fraudulent misrepresentation of failure to disclose, that an insurer can, in those circumstances, reduce its liability to nil in certain circumstances. So they say, well, you made an election to pay the claim despite the non-disclosure. You're stuck with that election. They say you are stopped, and furthermore, changing your position is a breach of the duty of utmost good faith. So in the end, things became litigious, and Delavue, or the insured, won at first instance in the federal court. It won before the full federal court. And then the matter went to the High Court, where the decision that matters most, and that's where Delavue's wins stopped, and the insurer was successful. It was a majority judgment. The High Court sat a bench of 5, Chief Justice Kiefel, Edelman, Stewart and Gleeson. Justice Gagler was dissented, and he found in accordance with the decisions below in the federal court. It's an interesting judgment in terms of dealing with issues of waiver, election, and estoppel, which you'll see there on the slide. And what's the analysis in respect of each of those issues was the type of analysis that would occur in a contractual matter, irrespective of whether it was an insurance policy. So the fact that the relevant analysis, the fact that it was an insurance policy, was not of particular significance. So in terms of the issue of waiver, had the insurer waived its ability to rely on the remedy afforded by Section 28, subsection 3 of the Insurance Contracts Act, that it could reduce its liability to nil, the High Court said, well, look, a waiver is rarely irrevocable. It can usually be revoked at any time, provided that you give reasonable notice. And sure, there are some exceptions. There are certain exceptions where a waiver is not revocable, and the example the court gave was legal professional privilege. For example, in the case involving waiver of privilege, once privilege is waived, well, as to use the slang, the genie's out of the bottle, as it were, and you can't unwaive it. But in most instances, waiver is capable of being revoked. Onto the second issue of election or election by affirmation, the essence, as I say, again, it's a purely contractual rather than insurance issue, but the essence of affirmation is that, or the essence of an election is that it needs to be an election between alternative and inconsistent rights. And the court said, on the facts of this case, that wasn't so, that in those circumstances that the insurer was able to, claw back its position because of the particular facts of the case. And finally, estoppel, that was unsuccessful as well. On the facts of the case, there had been no relevant reliance by the body corporate to its detriment. So in that case, well, it stopped. There was no relevant estoppel. The final key issue that was dealt with is utmost good faith. I'm sure you know every contract of insurance. Now, this is an insurance issue, of course. Every contract of insurance has implied into it a duty of utmost good faith. Was the case at common law, but it is enshrined in Section 13 of the Insurance Contracts Act. The court emphasised that, well, of course, this duty is imposed on both parties. It's imposed on the insurer and the insured. And when we talk about a situation where you've got a party that wishes to depart from a previous representation, if we was to say that an insurer can't do it on this occasion, it would follow that on another occasion that an insured couldn't do it. So ultimately, the court held that this was not a breach of the duty of utmost good faith to effectively backtrack on the previous proposal that they would waive the relevant non-disclosure. So obviously, it's a case that is very much determined by its facts. But having said that, I would suggest obviously that in any case where a party to an insurance contract is contemplating a change of position, it would be the starting point to look at, and to look at the circumstances in which that can occur. Isn't time to go through a full analysis of the judgments, but for me the key takeaways are the discussion in relation to that issue mentioned earlier, that being the waiver, and the fact that waivers are a clear statement from the High Court that waivers are rarely irrevocable, and that they can usually be revoked at any time and with reasonable notice, and that obviously applies beyond the scope of an insurance contract. And the other is very much in the insurance contract area is the duty of utmost good faith. The discussion there really very much suggests that I wouldn't say that it waters down the duty of utmost good faith, but it certainly doesn't empower it any further. So that you've got a situation where an insurer, having indicated that it was going to adopt one position, then subsequently, albeit in unusual circumstances, but then subsequently says, okay, this is our offer, you've got 21 days to accept it, otherwise you're on your own. In those circumstances, it was not considered to be a breach of the duty of utmost good faith. So that, as I say, that's an interesting decision, and certainly worth looking at if you find it, if you're looking at a situation where there's an insurer or indeed any party to a contract looking to change their position. The second case I want to refer to is the case of the New South Wales Court of Appeal from earlier this year. It seems to have generated a lot of comment and excitement. Case of Roberts and Goodwin Street developments, and it's a case arising from relatively new legislation, the Design and Building Practitioners Act 2020, and in particular Section 37 and the duty imposed by Section 37 of that Act. So you've got there, a person who carries out construction work has a duty to exercise reasonable care to avoid economic loss caused by defects in or related to a building for which the work is done and arising from the construction work. So the duty is owed to each owner of the land in relation to which the construction work is carried out, and to each subsequent owner of the land. So interesting provision. And then you've got a person to whom the duty of care is owed is entitled to damages for breach of the duty as if the duty were established by the common law. Now, the facts of this case were, let's just say curious, and involved the Roberts involved was a I think it was the director / employee of the building company DSD. So Goodwin or Goodwin Street Developments had engaged by contract DSD to construct boarding houses. This is around 2017. By 2018, a dispute had arisen regarding defects and rectification. That a defects notice was served. The builder did nothing to rectify. But what the builder, i.e. Roberts, did do was go on onto the building site and essentially cause some damage, sort of vandalise parts of the building site and the like, which was possibly not a very clever thing to do. He was sued personally for trespass, but what we're more concerned with today is that he was sued under this Act for breach of duty of care. Now, a real issue in the case, obviously at first instance before Justice Stevenson and then in the Court of Appeal, was the meaning of the word building and what buildings are referred to. There's potentially different definitions that it could refer to. There's a definition in this Act, and similarly, there is a broader definition in Environmental Protection EP&A Act, which was argued to be applicable by reference to provisions of this Act. Now, we could spend the whole time of this discussion and more, frankly, discussing the analysis in this case, and ultimately it's probably not fruitful, other than if you're a keen student of statutory interpretation. Suffice it to say, and it's disappointing given that we're dealing with an Act that was drafted in 2020, that some of the adjectives used to describe the application of the definitions by different judges that looked at the case have varied from, I think, the word labyrinthine, didn't say that correctly, but you know what I'm trying to say, and fiendish, as I think it was Justice Stevenson perhaps that used the term fiendish to describe the exercise of trying to ascertain what the correct definition. At the end of the day, the court found, consistent with the original finding from Justice Stevenson, that the duty to exercise reasonable care to avoid economic loss applies to all buildings as defined in the Environmental Planning and Assessment Act, and that's a very broad building. So the contra argument was based on an earlier definition in this particular act, in the, let's call it the DPA Act, which limited the scope of application to potentially to Class 2 buildings, as that essentially means apartment blocks. However, the court said having to undertake a very lengthy analysis and statutory interpretation. No, it's a broader application, and so the result of the judgment is that any building professional who has performed building work on a building that meets the definition under the EPA Act can face a claim for breach of duty of care under Section 37. So it's not just so in this case, as I say, it was the individual employee / director of the company who was liable. It's not merely the company itself, which by this stage has gone into liquidation. And it has real bite to it because the duty imposed by the Act operates retrospectively, and that's provided the economic loss is first apparent within 10 years before the commencement of the Act, or since its commencement. And as we saw up there, the duty is owed to current and subsequent owners of a building. So it's not limited to the party with whom there may be a contractual relationship, or at least the initial contracting party. And it's also relevant to say, watch this space as well, because there is a proposed amendment to the Act, the Building Bill 2002, which the public consultation period has ended, and my understanding is that it's proposed that it be enacted, so it operates by 1 July 2023, and that will have the effect of expanding further the operation so as to include work relating to commercial building products and subdivision work as well. It also extends the categories of professionals, well, at least assuming that these professions are not already covered, but to that extent it does potentially extend the categories of professionals to persons such as certifiers and the like. So that's that case. I'll move on now to the next matter of Shell Bay Constructions versus Hickey and others. So this is a claim against a firm of solicitors in negligence. It was, so a law firm had been sued in connection with legal services that it provided to its client, who was a property developer client. The developer, and they were selling off the plan, they were selling units off the plan. The developer was a party to contracts for those off-the-plan units. The way it worked was that the parties had a right to rescind if certain conditions were not met by a certain date designated to be the registration date. In fact, it was 12 months on. Now, the developer had the right to extend the registration date in certain circumstances, and that, for example, if construction or development's delayed by bad weather or other reasons, it did have the right to extend the registration date, provided it gave 1 month's notice. So, over a period of 2 years, on a number of occasions, on at least 5 occasions, different members of the law firm had given advice to the developer of the need to give notice in order to extend the registration date. There was no doubt that the developer was advised of the existence of the clause in the contracts. The developer was even provided from time to time with schedules that set out the dates of the contracts and the dates by which any notice for extension had to be given. It transpired that in respect of 2 particular units, the solicitors did not, with the clock ticking, the solicitors did not alert the developer to the impending deadlines, and so the developer did not give notice to extend the registration time in respect of those two contracts. The purchasers rescinded, and the developers suffered a loss because of the contracts could not be completed. They alleged that the solicitors were negligent for failing to warn of the impending deadlines. Now, I dare say I've given you the facts of that case, probably slanted in favour of the lawyers, because it is what it is. But I must say, it did seem a bit harsh, in my mind, that the solicitors were sued essentially for not having provided the relevant advice. They were sued essentially for not following up and making sure that this essentially being their safety net or risk management guarantee that they would advise of the imminent deadlines and the like. At first instance, however, the judge found that this was a breach of duty, and she found that it was Justice Adamson, and she found that the solicitors were liable. She did accept that there was contributory negligence on the part of the developer, and she reduced liability by 30% for contributory negligence. As I say, it went to the Court of Appeal, and in the Court of Appeal, the law firm was successful. No breach of duty. The law firm was not obliged to go beyond the express instructions. That's right, no breach. The law firm was not obliged to go beyond the express instructions, and that is to the extent that, well, the client had not instructed it to send notices in respect of these 2 properties. The client had instructed it to send notices in respect of other properties. But significantly, the law firm had repeatedly advised the client of the relevant contractual terms and registration dates, and having given ample advice, the law firm was, as I say, was not required essentially to be the client's safety net to essentially save it from itself. I sense that in the Court of Appeal, Justice White in particular felt aggrieved that the law firm was found negligent in the first place. In fact, to the bench said, look, having said that, we don't need to look at contributory negligence. Justice White says, yes, that's right, we don't need to look at contributory negligence, but if I had to look at contributory negligence, I would have found the developer 80% responsible. So that's quite interesting, almost his honour venting there. So there you have it, a good outcome for the law firm, and perhaps reassuring for all of us that ultimately, if you don't have to necessarily again, every case will depend on its facts, but look, you know, we're dealing here, it's significant, I think, we're dealing with a sophisticated client. They had been given ample advice. Frankly, the law firm shouldn't be held responsible for their failures. Then, finally dealing with a case of Malon Land versus Advanta Seeds. This is a case of the Queensland Court of Appeal, so we're venturing up north, and it's a case, it was a class action brought by farmers who purchased sorghum seeds manufactured by the company Advanta, or it was under a previous name, but anyway, ultimately it's Advanta, and the seeds were contaminated, and they had suffered pure economic loss as a result of the contaminated seeds. Now, I say contaminated seeds and pure economic loss, and you think, oh, that sounds familiar. Well, of course, one of the key judgments on pure economic loss is a case from 1999 of Perry and Appand. Fun fact, if you Google Perry and Appand, there's a good chance that one of the first things that will come up on the Google search is an article written by me in about 1998 or 99. I only know that because I happened to do that earlier this afternoon. But anyway, I've digressed, I'll come back. So what was significant in relation to this case was that the seeds that were, and bear in mind they weren't bought by the farmers from the manufacturer. The manufacturer had provided them to a supplier, and they bought it from the agrarian supplier. They're packaged in a bag which contained a tag with printed terms and conditions. I'll go into some details of those in a moment. Those terms and conditions included a disclaimer of liability, and indeed a warning that there was a risk of there being contaminated seeds. But just briefly backtracking a bit in terms of the law on pure economic loss. As I said, I mentioned Perry and Appand, and whenever, of course, you hear that name, it's about the company that makes the kettle crisps. You always feel like you want a kettle crisp. So in that case, the High Court held that there could be recovery for pure economic loss due to reasonable foreseeability of damage, and because the applicant fell into an ascertainable class of persons who are vulnerable to the respondent's actions. So again, two key issues there. First of all, you've got an ascertainable class of people that would be affected by the actions of the, let's call it the negligent party. And secondly, you've got vulnerability on the part of the plaintiffs, the person bringing the action. So that was a decision of the High Court in 1999. Subsequently, High Court looked at the issue of pure economic loss again in a very different context. A case of, in 2014, Brookfield Multiplex versus Owners Corporation 61288. In that case, they involved the cost of latent repair defects in common property incurred by the Owners Corporation due to negligent design and construction. Brookfield was the builder of an apartment block, and it did not have a contractual relationship with the corporation. There was provision in the contract for purchase of apartments to have rights against Brookfield, but that did not extend to the OC. In those circumstances, the High Court found that no duty of care was owned by Brookfield to the Owners Corp. Again, familiar language that you see in these pure economic loss cases, and in particular, there's an interesting judgment of Chief Justice French, ultimately, again, emphasising the issue of known reliance or dependence on the part of the plaintiff. When I say that, I mean the defendant, the negligent party, knows that other persons are relying on it to not breach its duty. And secondly, an assumption, another factor said to be relevant, is the assumption of responsibility by the defendant, or there may be a combination of those two factors, vulnerability and assumption of responsibility. In this case, Malham Land versus Advanta Seeds, the court essentially affirmed the Queensland Court of Appeal affirmed the single judge, finding that the disclaimer negated an assumption of responsibility by the manufacturer, and therefore a duty of care did not arise, despite essentially them finding that, well, yeah, the farmers were in a vulnerable position, but having said that, this disclaimer negates the situation. A significant factor in the case was the wording of the conditions. To quote from the judgment, the relevant wordings, which was on a label or tag attached to each sack containing the seeds, it was not phrased in what was described as an archaic or overly legalistic way. It was plain language was used, and it conveyed several clear propositions. It said, for example, in a direct manner, the bag, that's a bag of seeds, may only be opened if the buyer had read and agreed with the conditions. You could return the bag if the conditions were not acceptable. And then if the product in the bag did not comply with the description, then Advanta, its liability would be limited to the cost of replacement of the product. And then it said Advanta would not be liable for loss or damage caused by use of the products, including by its negligence. So the court held that certainly these conditions, these matters would be readily understood by buyers, and indeed that was clear on the face of it. In those circumstances, then, they thought that the court thought that the nature of that disclaimer was such as to effectively negate the key element of assumption of responsibility, because they have disclaimed an assumption of responsibility and have in particular imposed that condition that, if you're not happy with these conditions, you can return the product and we'll give you your money back. So in those circumstances, despite the relative vulnerability of the farmers, it was held that there was no liability. And there's, for want of a better term, I used to say interesting, there is an interesting discussion when by the trial judge, and commented, I think, on in the Court of Appeal in Queensland, where they essentially say, acknowledging the responsibility and more or less saying it's a bit tough on these guys, on the farmers, but having said that, I'm afraid we can't. The law is what the law is, and in the absence of the assumption of responsibility, we're not going to impose a duty of care. So that was that case. As I say, that was a decision of the Queensland Court of Appeal from, I think it was earlier this month. I've sort of whizzed through them more quickly than I expected, but I'm happy. I don't know, Jackie, if there are any questions that have arisen? Not yet, but hopefully shortly. Well, I've just encouraged everybody to ask questions. Yeah. look, I can't say that that was a matter that seemed to deadlines on the planting that arose on the facts. I think the reality is the farmers were aware of the condition. I think they didn't pay much attention to those conditions. What they were more concerned about, and the evidence was that they were more concerned on the germination data. So other elements.
I just wondered.
Well, it's true. That certainly wasn't evidence in the case, and there's certainly no evidence that, as far as I'm aware, that address the issue of, well, was there another product available on the market? You would assume that there was, but that wasn't. They didn't enter into the discussion. But I think a couple of the cases that I'm just going to ramble on now. Have the opportunity to talk freely. I'd say there's probably of the various cases, I think there's two in particular that will have ongoing impact and cause certain, depending on what interests you represent or who you are, cause instant consternation. That's, of course, the High Court's decision in the Allianz and Delaware View. I personally, I find the part of that case I find most interesting is the notion that the discussion in relation to waiver and the fact that, generally speaking, the High Court said in very clear terms that, usually speaking, you can waiver is not irrevocable. But also it'd be interesting to see how the courts look at the issue of utmost good faith going forward, because they've as good as said that, well, utmost good faith doesn't mean you have to be. I was going to say you don't have to be squeaky clean. That's probably the wrong thing to say, but it's certainly, anyway, you don't get the impression that it necessarily is a high bar based on that decision. And the other one, of course, is the case of Roberts and Goodwin. I think there is, just from, you see what the commentary that you see online in forums, for example, such as LinkedIn or whatever, that I think there is a degree of concern as to the potential breadth of liability that can be imposed pursuant to Section 37 of the Act, and it, as I say, it looks likely that with amendments to the Act that breadth of liability will get wider in terms of the type of what constitutes building work and also the potential professionals that would be liable. But yes, Jackie.
Would that have an impact on what is, Sydney's greatest activity, which is property development? Do you think there would be a flow-on effect for those developers that are currently?
Look, I'm not an expert, so you're saying would the potential for legal liability have an impact on property development? Well, I guess it can potentially have an impact on insurance premiums, but which I imagine are not cheap to start with. But look, it's hard to judge, but I think this is Sydney. We love property development so much. Nothing can stop it. Not even this Act. Because if there's nothing else, we might wrap it up. I think we're close enough to 1 hour to have gotten our point. And if not, I encourage you to just spend 5 or 10 minutes just thinking about what we've discussed tonight. But no, but seriously, thanks so much for joining me, and I wish you goodbye. Thank you.